Hello, welcome to our monthly Facebook Live. I am founder of the Art of Estate Planning, Tara Lucke, and today's topic is powers of attorney for companies, trusts, and SMSFs. So I am so pleased that you are joining me today, and if you are watching the replay, welcome as well. So before we dive into it, I want to acknowledge that I am hosting this training from the lands of the Tarabulung Bunda people in the Bundaberg region. I want to acknowledge the traditional custodians of the lands on which each of you are living, learning, and working from today, and pay my respects to elders past, present, and emerging, and celebrate the diversity of Aboriginal and Torres Strait Islander peoples and their ongoing cultures and connections to the lands and waters of Australia. Okay, before we jump straight in, I'm going to just make sure that we are live in the Facebook group so people can see. Yep, let me pin myself to the top of the thread. Okay, so hopefully we're cooking with gas. All right, as usual, please ask questions. I can see who they are, and yeah, let's make this interactive. Now, I will say this is a shorter presentation of a 90-minute training that we did in the TT Precedents Club. So I am going to cover a lot of things quite at a high level. If you're a lawyer and you want to do a deeper dive, come join us in the TT Precedents Club and you can still get access to that previous training. So let's start with some core principles around powers of attorney for entities. Actually, before I dive into the core principles, I just want to put this into context that for clients where you are helping them with their estate planning and they have a trading business, the entity power of attorney can really be the final piece of the puzzle to make sure everything runs as smoothly as possible if one of the controllers dies or loses capacity. It's not for every client. We're going to talk today about when is it going to be a great value add and when might it be over the top. Okay, so core principles, I'll just touch on this very lightly. So it's a formal instrument in writing that we're talking about today in the context of a trust company or self-managed super fund that affects a relationship where one person, the principal, vests in another person, the attorney, power and authority to perform acts on the principal's behalf. So I've taken that from the Del Pont power of attorney text. And in today's training, there's different terms that we can use. I'm going to use the word principal to reflect, the donor of the power, and attorney to be the person receiving the authorizations to act on behalf of the principal. So just to be really clear, power of attorney is not granting any proprietary or ownership interest. It's only like an agency or authority arrangement. It's not a contractual arrangement and it's not a trust relationship. There's also a few limitations or things that I think are common misconceptions that I wanted to clear up in the entity power of attorney space and just deal with it head on. So sometimes people might assume, and your clients might assume, that if they make a personal enduring power of attorney, then that is enough to deal with the assets that they may control directly or indirectly through a trust. Not the case. Also, if they are a company director, their individual power of attorney does not apply to their roles as the director. And in fact, the attorney for the individual trustees, power of attorney can't act for the SMSF either. So another thing, directors and trustees are still able to act while the power of attorney is in place. So you don't lose your authority by granting the power of attorney. It's an and solution. So the original directors or trustee plus the attorney can act. You also have to be careful where individuals, trustees cannot appoint an enduring power of attorney. And I'll talk about this in a moment, but there's a bit of a nuance there in terms of when are these revoked due to loss of capacity of controllers. So we're going to dive into each of the cases and I'll explain that in more detail there. So I'm not setting out every single legislative reference, But I've just shown an example from the New South Wales Power of Attorney Act. Most states will have a similar prohibition, just confirming that the enduring power of attorney cannot be used to confer authority in the role of a trustee. Okay, so you can't use your enduring power of attorney to delegate. So let's start. When is an entity power of attorney a good recommendation as part of your estate planning exercise? And it really comes down to a combination of timing and activities of the entity. So when we are dealing with, for instance, a company or a corporate trustee with a sole director or perhaps two directors, that's probably the best case where I think an power of attorney would be useful, okay? Because the reality is we want to use this as a triage strategy to keep everything going and operating while everyone scrambles and gets the right paperwork in place, works out who is taking on succession of those control roles. So if you've got like a company with a sole director and that sole director loses capacity, pretty much everything is frozen until we go through the mechanisms to appoint the replacement. Okay. It's also relevant looking at if you've got an activity coming up that requires a special or unanimous resolution and you've got a multi director company, then perhaps a power of attorney for that transaction would be useful as well. So it's not as important for the individual trustee role, the appointer, principal, or guardian role, provided your trustee contains appropriate succession mechanisms. Usually, it's not as relevant where you do have multiple directors of a company if they can still pass a majority resolution. 99% of activities can still be conducted. And it's not really that important where you have an entity that is a passive entity. So, what we're really talking about here is a company or a trust that has activities that are going to need someone to take the helm and have control in an emergency. So things like where you are trading, basically, if you've got staff and wages to pay, bank accounts to access, accounts payable to pay, you're entering into contracts consistently and regularly. You need to hire staff to replace a key person if someone has been lost in an emergency, if you need someone qualified to keep third-party licensing. So all the lawyers watching, this is a requirement for us. The Queensland Law Society particularly has been really pushing this in the last 6 months that, if you don't have a lawyer with a principal practicing certificate who can take over your firm within 7 days, you have to stop trading. I think there's a lot of things like that in terms of perhaps building licenses, other professions with qualifications as well. And it's also important you can use the power of attorney for a defined purpose where you do have controllers traveling overseas or people who are overseas regularly, and there's like a specific transaction that needs to be entered into. So again, passive vehicles that don't have a lot of like regular transactions, no staff or wages, anything like that. I probably wouldn't be pushing the power of attorney solution for those. You can always do it. It's, nice to have. But if you're sort of sitting there going, oh, I don't want to be overselling my services, then, I'd really focus on the clients who have trading entities for recommending this as a solution. So here we've got a scenario. Hopefully my pen will work for me. So for instance, we've got at the bottom a trading company with a sole director. It's owned by a holding company with a sole director, and it doesn't really do anything except receive maybe dividends from the trading company and have bank accounts with retained profits. And it's ultimately owned by a family trust with a corporate trustee and our individual. I'd probably, in this structure, only recommend the power of attorney for the trading company. Now, in reality, if your power of attorney deed is going to be very similar for all of these entities, just with, changing the name, then sure, maybe put it in place for all of them. But in terms of pushing the recommendation, it's the trading company that has staff, contracts to enter into, accounts payable, all of that, which will need financing issues, all of that, which will need the power of attorney. So, another thing I'll just mention briefly is when you are preparing this, especially as the lawyers who are listening, do your entity due diligence to make sure that you really understand the structure. Don't take the client at face value of how they say it's set up. So, for instance, it's essential to understand if the company is acting as a trustee or not. And you do need to, I'll show you in a moment, there's a different threshold for if you're delegating as trustee versus if you're delegating just as the company under the Corporations Act. So I'm sure you all know how to do this, but just briefly, go to the source, look at the ASIC search to confirm the beneficial ownership of the shares. And I also like to make sure I look at the financial statements, and particularly the balance sheet for each entity, because you would want to make sure that there's any business assets. The profit and loss should reveal as well, those wages coming out, sales, accounts receivable. So, is that showing up on the company's profit and loss, or is it showing up on a trust profit and loss? And that will reveal if they're acting as trustee or not. I'm sure you all really know how to do this as well, but when you're searching and looking at that ASIC search, beneficially held means that the shares are not held on trust. If this says no, then the shares will be held on trust. But you can't always rely on just this. Back when I used to do a lot of structuring work, this would often be inconsistent with what the financial statements said, because whenever this requirement to record beneficial ownership was introduced, I think a lot of people didn't understand it. And so a lot of entities, particularly older ones, were recorded with ASIC with this incorrectly. So go to the extra step and verify what's happening through the financial statements as well. Okay, so powers of attorney for companies. We've got a company appointing a power of attorney. A little refresher on the Corporations Act. So you probably all know this, but it is the shareholders or members of the company which appoint the directors of the company. So the shareholder passes a resolution to decide who the director is and removes them. It's the starting point. An individual shareholder's power of attorney can take action with respect to the shareholding. So if our person here dies and they appoint an attorney, well, their attorney can actually pass that resolution to appoint and change the director. Okay, but it doesn't work in relation to the director itself. So that if our director loses capacity, their attorney cannot step in and act. Okay, that doesn't work. So in that case, the shareholder would need to appoint a new director, not the attorney of the director just stepping in. I'll show you a little bit about 201K in a moment, but to elaborate this point further, when you appoint an attorney, it is the company which appoints the attorney. So our purple attorney, once appointed, signs on behalf of the company. So anything that the company is entering into, if it's a contract, if it's paying wages, all of that, the attorney acts not for the directors, but for the entire company as a whole. So if you're looking at an execution clause, normally it would have, PTY Ltd signing director 1, director 2, or director secretary, and they would sign, navy, green, or pink person would sign. That's not what's going to happen. We were going to have one execution clause with one signature, and it's purple signing on behalf of the company, not purple signing on behalf of the directors. So hopefully I've clarified that point, because it's a really important thing to get your head around. So it all comes back to this idea that, under 201K, the power of the directors themselves are personal, and it's not possible for them to delegate. You can have the individual directors appointing an alternate director, but when the director who appointed the alternate dies or loses capacity, that appointment of the alternate ceases. It's revoked straight away. Just a couple of principles going back to the Corporations Act. So Section 124 confirms a company has legal capacity and powers of an individual, which means they can appoint an attorney at common law. You don't officially need a power to delegate in the Constitution. Now, 201F is also a useful rule in the Corporations Act to know, and it basically says where you have the same individual who is the shareholder and director of the company and they lose capacity. Here's the section to look at here. Then the personal representative of that person can appoint a new director of the company. Okay, so we have got a bit of a fail-safe here. So if they lose capacity, the attorney, or if they die, the executor or administrator gets to decide who the new director is. But it's slow. So in general power of attorney that I would suggest you would put in place when they're trading is like a triage or an emergency solution. It's to deal with things fast in a temporary way while we sort out the management and control of the structure in the background. So for instance, relying on 201F, technically you might need probate to prove that when that sole person has died, the executor is the person with the authority to then appoint the new director. Even if we've got a incapacity situation and you've got a enduring power of attorney, which would be faster than having to get probate on death, incapacity, we can just go straight to that enduring power of attorney and rely on it, assuming it's valid. You still have that enduring power of attorney. They need to pass a resolution. They need paperwork to sign to appoint the new director. You need to lodge it with ASIC. So if you are dealing with third parties, that company's dealing with third parties, having a power of attorney for the company means you can basically act immediately while you go through those notifications and resolution processes and satisfy the third party who that new director is. Now, look, you could probably whip up these things reasonably quickly, and it might just be a matter of buying yourselves a few days or something. But it does mean that when our incapacitated or deceased director shareholder dies, within the next second, our attorney for the entity can start acting versus a few days. So I'm not saying that this is like a long-term solution, but it just means you can have business continuity. So let's look at individuals. There is an ability to delegate and appoint an attorney both under statute and at common law. So the common law power of attorney is generally more flexible, but you cannot make an enduring power of attorney at common law. So just a refresher, a general power of attorney means that it ends when the principal loses capacity. So it can start immediately. Well, it has to start immediately. And then when the principal who gave the authorization dies or loses capacity, it's revoked. It ends. Versus an enduring power of attorney, which is what most of us would prepare under an estate plan, where it endures past the principal's losing capacity. Obviously, it ends when the principal dies, and that's where we're in the territory of the will. But the enduring power of attorney means the attorney can still act even if the principal has lost capacity. So, the ability to make an enduring power of attorney is actually rooted in our state's legislation. So there's statutory requirements and authorizations allowing us to do that. So at the common law, we can make a general power of attorney without reference to the legislation, or if we want to make a general power of attorney, we can go to our state legislation as well. But it's a bit more narrower. So just to be clear, you might still want to make a general power of attorney for an individual when you know that individual is going overseas and they want to appoint someone who's not appointed under their enduring power of attorney, or perhaps their enduring power of attorney only starts when they lose capacity. So they want to appoint the attorney because the individual is going overseas, there's a transaction that needs to be signed, and you might say, well, the general power of attorney is only for a limited time or only to complete this particular transaction. So you can set parameters around it. But know that when the individual donor or principal loses capacity, that general power of attorney ends. Okay, so trustees, a little bit different to the companies and a little bit different to the individuals, but also we've got to import those rules as well, because you can have a company as a trustee or you can have an individual as a trustee. So, at the general law, trustees have a duty to act personally, which as a starting point prevents the trustee from delegating their duties, powers, and discretions. There is a very narrow or limited legislative basis in each state to allow the trustee to appoint an agent. Usually it's when the trustee is out of state or temporarily incapable of performing their duties. The state legislation is all a little bit different. And that is subject to the terms of the trust deed. So if you have a trust deed which has an express power allowing the trustee to delegate, then you can rely on that at common law, that common law power in the trust deed, rather than the narrower legislative basis and, the power in the Trustee Act or whatever. Where we've got a corporate trustee, then we also import the rules in the Corporations Act. So where you've got a corporate trustee, and an express power in the trust deed, they can make a general power of attorney deed. And it actually does endure because the company can't die. So obviously if the company's deregistered, it ends. But if a director or shareholder of the company loses capacity, the general power of attorney continues because it is the company and not the directors which make the power of attorney deed. Where you have an individual, like a human person as trustee, then there's an argument that the power of attorney deed only continues while that human person has capacity. So I actually, Carrie and I actually spent a lot of time diving into this because I had, historically always thought that it was the trust which continued and it didn't matter about the individual trustee losing capacity. But, when you do look at the rules relating to individuals and it being a general power of attorney, I can't find any authority anywhere which says that if you're an individual and you make a general power of attorney for your powers as trustee, that it endures beyond your capacity. So I think the best or the safest thing to do where you've got individual trustees want to make a power of attorney deed is to make sure, of course, that it only applies while the trustee has capacity. So it's more for that overseas, out of the jurisdiction case or a specific transaction case, not as part of the succession plan. So let's see. Yeah, I've got a few more notes on that. So I'll put the slides up. These are your sections in the specific state acts, which has that legislative basis for delegating as a trustee, but again, very, very narrow. I wouldn't rely on this. I'd be relying on the trust deed. So I think the better solution where you've got like an individual trustee who's a person is that you get your succession plan and succession mechanism within the trust deed really dialed in, and have like a deed of successor, appoint or deed of successor trustee prepared, rather than relying on the general power of attorney, because I would say there's a real risk that the general power of attorney ends when the trustee loses capacity or dies. The reality is, I think it would be a very unlikely scenario that you would have this structure with an individual trustee carrying on trading activities and needing a general power of attorney deed for business continuity anyway. Because if we go back to our asset protection 101, our trustee here is personally liable for the debts of the trust. So if they are, if that's me and I've got my house, I've got my investments, whatever, in my own name, I'm putting all of those personal assets at risk for the activities of the business. So, if you are presented with that scenario, I'd consider the first recommendation is appointing a corporate trustee to get limited liability. And then when you have got a corporate trustee, you can make a general power of attorney that endures. So I will just round this out before we look at the corporate trustee scenario. If you're not aware of it, we at the Art of Estate Planning have a really great trust succession precedent pack. So it has a deed of variation template with the exact clauses that you should put into your family trust deed that allows for succession of the control roles: trustee, appointer, principal, guardian, all of that. So ability to appoint and nominate a successor, what happens as an automatic disqualification, the whole thing. And then it also comes with template deeds of succession for all of those control roles as well. So that makes it really simple and easy to tidy that up when you've got an individual as trustee of a family trust. What happens where we've got a corporate trustee and the director loses capacity? I've just said here the trust deed is not relevant. I don't think that's right. The trust deed is absolutely relevant because the company, the trust deed becomes less relevant automatically. What happens if you want to make a general power of attorney? The trust deed is super relevant, but let's just work through what happens if you don't have a general power of attorney. I think that's what I was thinking here. So again, the trust deed mechanism doesn't really come into play unless you've tailored some really bespoke provisions here, because if our director loses capacity, the trustee doesn't change. The trustee just the trustee just keeps on keeping on as a corporate entity. So then we're looking at, well, what is going to happen under the Corporations Act and the Constitution? So they'd be automatically retired as a director. Our shareholder has to pass a resolution to appoint a new director. ASIC has to get notified, all of that. So this is where your general power of attorney is a really good solution to just keep everything going. The next second, you've got an attorney who can step in and act for that trustee company and, keep on keeping on. If we've got a situation where we've got our trading company and it's in fact owned by a family trust with a corporate trustee, and these two people are the same person, then what we need to sort of do is two lots of resolutions to ultimately get a new director appointed for our trading company, right? So our first lot of resolutions is our shareholder, assuming they still have capacity, has to appoint a director for the corporate trustee, make those resolutions, notify ASIC, all of that. Then our new director of the corporate trustee as shareholder for the family trust then has to appoint, I'll get rid of this red, the new director of the trading company. So we've then got another set of resolutions and ASIC notifications. So again, in this scenario, the power of attorney, it's a really good triage solution. 1 second later, after our individual director loses capacity or dies, we've got our general power of attorney that keeps on keeping on, and they can just keep, sorting everything out that needs to happen for the business, which is a huge relief, right? If you have got a key person, key controller of the business dying or losing capacity, having someone to just step in, having the authority to do whatever needs to happen is going to really take the pressure off. Like, it is going to be a mess. It's going to be crazy. It's going to be a mess if your key person dies or loses capacity, especially when you've got staff, customers, the whole thing. If you need to hire in and recruit a key person to replace it, like, it's a stressful time. And adding to that stress, in particular, if no one can actually do anything and the people who want to get in their hands dirty and sort this out have their hands tied because they don't have the legal authority. So that is where the company and trustee power of attorney really shines and is a great value add on top of the estate planning documents that you're preparing for the controllers and shareholders. SMSFs. Oh, I'm just looking. I'll just check the questions. Can I please clarify, can you always appoint an attorney for a company, whether it's a company that trades or is acting as a trustee? Or is it that if it's a company acting as trustee, you have to check the trust deed has an express power? Yes, it's the latter. So I'll just jump to, I've got a slide on that one. So yeah, the actual, how do you do it and what's the process? It's a great question. So when it's a trust, you really need the specific authority in the deed when you're a trustee. So the company, because of Section 124 of the Corporations Act, it has the ability to do anything that a person can do, which is allow a common law, a person can enter into a power of attorney. So it's the same for the corporate trustee, but if they want to delegate their powers and duties and discretions under the trust deed, then they have to be specifically authorized by the trustee to do it, because the legislative basis is very narrow and it's not enough. So yeah, always make sure that you have the right power to delegate in the deed. Okay, I'll jump on back quickly to the SMSF. Thank you for that question. And sorry, I should just check who it is. Oh, it's Danielle. That's a great question, Danielle. Thank you. Okay, so quickly covering on SMSFs. Oh, has that come off now, Jennifer? I've tried to remove it. There might be a tiny delay. If the question is still covering the slide, let me know. Hopefully it's come off now. Okay, I'm just going to assume it's fixed. Oh, yeah, great. Thank you. Sorry, I do think there's a slight delay. Okay, SMSFs. Now, this is a whole topic in its own. I'm going to touch on this really briefly. So, conceptually, when we're talking about the self-managed super fund, there's two sort of issues to think about. There's, okay, what about the members and the directors? And then there's the attorney for the self-managed super fund as a whole, right? So the general power of attorney that you could prepare for a self-managed super fund is really only useful for the fund as a whole on this right-hand side over here. So, is this fund entering into some kind of contract where we might need someone to sign on behalf of the directors or the trustees? So I actually think there's a very limited scenario where a super fund would need a general power of attorney. I think it's quite unlikely. The only one I can kind of think of is if like the fund is doing something where they're buying a property or entering into some kind of contract, and there's a situation where the people who need to sign on behalf of the fund, or the trustees of the fund, can't sign in that immediate situation. I think otherwise it's pretty unlikely, but I'm happy to be corrected if there's people who can think of scenarios. I'd love to hear. So I don't often think you would be needing to recommend this solution for a self-managed super fund. However, because of the way the SIS rules work, a personal enduring power of attorney, and an enduring power of attorney, not a general power of attorney, for our members and directors and trustees is really important. So you're all probably familiar with the Section 17A of the SIS Act, which basically says like every member of the fund must be an individual trustee or a director of the corporate trustee. And if you've got a sole member fund, then the member must be the director or only one of two directors, and the other one must be a relative, right? So there's an exception to that, which says the legal personal representative of a member can be a trustee or a director of a trustee, and the fund will still comply with Section 17A. So having an attorney appointed under an enduring power of attorney is very important if you want to keep your fund compliant for a member who has lost capacity. Now, I'll just mention we had that case, Ipolo and Conti, which says the mechanism in Section 17A(3) doesn't actually go as far as appointing the legal personal representative, executor, or attorney to the role of director or trustee, just that it is Section 17A really just means the fund will still be compliant if you do that. So you still need to go through those appointment resolutions and notifications. If you need to dive into this, this ruling here has a really good summary. In particular, I've just highlighted in pink, the legal personal representative needs to be an enduring power of attorney, not a general power of attorney. And that's like obvious, right? Because we're dealing with individual trustees and individual members, and the general power of attorney ceases when an individual loses capacity. And this is obviously a loss of capacity scenario. So yeah, so look, I won't dive into that anymore, other than to say I think the scenario where a self-managed super fund needs a general power of attorney is going to be really narrow. And if you are looking at it, just remember it's for the fund as a whole, not the members. So how do you actually appoint I'll just quick check. There's another question. So thank you for the questions. And Danielle's asking, does it only work for incapacity? Can someone with capacity resign and then let their enduring attorney act as director? Okay, so we've got an individual, they've got capacity. I'm the individual, I'm trustee, I'm the individual, I'm director of a company. I've still got capacity. So my options are, okay, going back to Principles 101, the shareholders appoint the director. So if I resigned as director, then whoever's the shareholder of the company could appoint a new director. I do believe there's also a rule, can't think of it off the top of my head, where the directors actually can appoint new directors as long as the shareholders ratify it. So I think the shareholder can veto it. So technically I could resign and try to appoint my enduring attorney as the director, but it wouldn't happen just by virtue of that person being my enduring attorney. I could also appoint my attorney as an alternate director, but as soon as I lost capacity, it was removed. So The scenarios of using a general attorney means the attorney acts for the company. So, say I had a company with myself and my husband as the directors. We'll just go have a look at my diagram. Why don't I do that? Here. So, we've got our company with 3 directors. So, all 3 directors of the company have to pass the deed or enter into the deed and pass the resolution to approve to appoint the attorney. Now, if we've got a situation where our Navy person dies or loses capacity, a document or a contract on behalf of that company could be executed by Pink and Green, because together they have enough to Oh, sorry, Danielle. Are you talking about the self-managed super fund case? I might have gone off a little tangent here. But yeah, so back to what I was saying, Pink and Green together have have enough to pass a majority resolution, so they could enter into the contract on behalf of the company, or Purple on their own could do it as attorney for the company. But yes, sorry, I think I've misunderstood that, and you're talking about the self-managed super fund case. And yes, sorry, and Jennifer's answered that. Thank you. Okay, so let's go back to how do you appoint an entity attorney? So you need obviously the authority to do it. Companies are pretty easy. You've just got common law power and the legislation, and you need a deed. You need a written power of attorney deed. Trusts and self-managed super funds, you need that plus the specific authority in the trust deed. Okay, so make sure if you're doing it for a trust that you do a trust deed audit, you review it, make sure it has the necessary power, or you might need to update the deed to add in or customize that power before you actually go ahead with preparing the power of attorney deed. So that's quite important. Okay. Also, a side thing, I haven't gone into all the registration requirements here, but do be aware that often when dealing with real property, that you have to register your power of attorney with your relevant titles authority as well. So that will be quite important. I know different states have different requirements around the timing of that. I think, like for instance, Western Australia, you have only like 3 months or something since making the power of attorney before it can be registered, or there's challenges and fees and that type of thing. I know in Queensland, we would make a power of attorney and not register it until right before we knew we needed to use it for a specific transaction. So if there was no contemplated property transaction, we wouldn't register it until we needed to. So it just depends, but that's something to bear in mind and filter into your process. Maybe it needs to be notified with the financier under the finance documents, and maybe you even need their consent. I'm not sure, not a finance lawyer, but that could be a thing to be aware of. You also want to put the power of attorney document itself in the entity register as well, so everybody knows about it. So just some practical considerations to be aware of. Another thing from a practical perspective is thinking about doing this in conjunction with the estate plan for the controllers behind the entity and aligning it with that succession plan. So not doing this in isolation. There's a couple of basic things, like for instance, if you're appointing multiple attorneys, which you can, are they acting jointly or jointly and severally? Obviously, if you're appointing individuals as an attorney, then get the basics right. They have to be over 18, Australian resident, legal capacity. You can also appoint a company as an attorney for a company or a trust. Getting more specific into adding value, how you can add value to the clients in this way, is thinking about how is this all going to play through under the estate plan for the individual director or people behind it. So is it going to be, are the attorneys for the entity the same as the executors or personal attorneys under the enduring power of attorney, or should they be different? And thinking about this in the context of the activities of the entity, like, are we paying wages? Are we controlling and accessing company bank accounts? Will it need to be sales and exits and employment contracts and all of that negotiated by the new attorney for the entity? So sometimes I've seen it where we've got a trading business and the controllers of the trading business will say, actually, we want our general manager to be the attorney for the entity. And on its face, that makes sense, right? Because we've got a general manager who knows the business really well. They can just jump straight in and sort things out. But are we actually reducing internal controls, giving that general manager, who has their own wages to be paid, carte blanche to, access the bank account, and we creating an opportunity for fraud or the funds to be stolen from the company? If you've got a situation where there's like a call option for that general manager to buy out some of the shares, or there's an employee share option scheme or something like that in place, and the general manager is and that's part of their incentives, is the general manager suddenly like negotiating or transacting with themselves on behalf of the company and then also themselves? Same with flip side, right? If we're like, okay, well, the directors have appointed under their personal enduring power of attorney their business partners. If both spouses have died or something like that, it's their business partners because they're best friends with them as well. And that makes sense. They trust them for their personal estate plan. But we've got an insurance funded buy-sell deed in place for that entity. And have we got our business partners negotiating with themselves on behalf of the entity and everything? Is it messy or not? So just, thinking through like the full plan and playing it out step by step as to who is going to be the right people. Do we want it the same as the executors and personal attorneys? Do we want them to be someone involved in the business, or do we want a combination of both? And that's where I think, you can really help the client to think beyond just like their gut reaction and really stress test, how are we going to make this triage plan with the general power of attorney that gets us up and operating immediately, but also has the protections and controls in place. Other things to think about is, yes, the experience, particularly the fact that this is more than, sometimes people appoint for their financial attorneys the people who they want to be as guardian for their children and medical attorneys, right? But if we've got a trading entity, then actually maybe we need someone with a lot of financial sophistication, perhaps someone not super close who's going to be, have fallen in the corner in a heap when disaster strikes, who's going to be able to step up, take the reins, and keep this business going. Internal controls I just mentioned. And then also just check, like triple check that there's no disqualification in the constitution or the trust deed that means a particular person can't act on behalf of the entity. Also with appropriate experience, this also ties back to depending on the nature of the business. Like, as I said before at the very beginning, if it's a law firm, do you need someone with a principal practicing certificate to be one of the attorneys? Like, is there a requirement there? So the next thing I'll mention is defining the scope of the appointment. I often get asked when I've done this presentation before, can we just use the titles office issued general power of attorney form? And why do we need to do like a special deed? And it's around this part of the presentation and these issues where the tailored, customized general power of attorney deed really shines compared to that standard issue titles office form. So I know in Queensland, I think we have that. I don't know if you have it in other states, like it's like a 2-pager form. Whereas like what I would recommend is like a much more comprehensive deed. So these are the things that you would put into drafting the general power of attorney, really dialing in the powers. Is it just an open general power of delegation that anything the principal can do, the attorney can do? Or is it for a specific or limited purpose, like only for negotiating and signing these exact documents with this exact entity, or only while I'm overseas, that kind of thing? Is it you can do anything that the principal could do, provided it's in the ordinary course of business, provided it's not over this financial limitation, or there's no conflict of interest, or it's not with a related party, or that type of thing. Putting in express authorizations that third party registers would want to see, yes, you can specifically deal with real property under this, or you can specifically transact my shares, all of those kinds of things. So you can really customize this in the deed, which I would encourage you to do and work through with the client. Where's the balance between giving the attorney enough authorization to do what they need to do, but maybe bringing in some checks and balances. Again, going back to that issue of, is there a special qualification that the attorney must hold and continue to hold? What happens if your attorney does have that qualification, but then they lose that qualification, their license is removed from them? Do they then cease to be appointed as an attorney? And if you're appointing multiple attorneys, really defining, are they acting jointly and severally? Have we got substitutes replacing them if they can't act? So in our precedent document, it's like, what happens if our attorney loses capacity or dies while they are acting as attorney, before they are acting? If we've got joint people, is the successor attorney acting to fill the vacancy? All of that you customize beyond what you can do in like a standard titles office form. Other things that I would recommend you turn your mind to: conflict of interest transactions, remuneration. Now, a lot of attorneys don't get remunerated, right? But when we're talking about it in a business capacity, particularly if they're already an employee, or we're changing their duties, or it's, what we're doing is keeping a profit-making operation going, remuneration could be entirely appropriate for the attorney, especially like they're not like passive activities that they might have to step in. It's very important. So considering about remuneration, indemnities, express process for reimbursement. An attorney can't delegate their powers under the power of attorney, so prohibiting that, and then also saying what happens if the attorney can't fulfill their roles, specifying revocation of previous general powers of attorney, and that this one replaces that, but also the circumstances where this general power of attorney will be revoked. So really getting clear about your start and end time. Like, is it just effective immediately? Is it a springing event? So when a certain condition or event happens, that's when the attorney powers happen. Is it conditional on something, on a specific date? And I've said enduring, that's really only in the context of companies that works. And the end time as well. Is it just for while I'm overseas during this period, or after this transaction has ended? Notice, can the principal just revoke it by notice? Is it irrevocable? From my research, irrevocable powers of attorney is a whole topic on itself, so I'm not covering that in this presentation. Insolvency, death, incapacity of the principal if we're an individual, all of that. So these are the things you would want to cover in your document. A couple of things to try not to mess up. So yes, express power is critical. If you take one thing away, if you're dealing with a trust or a self-managed super fund, you must have an express power to allow the delegation. Um, it also needs to be really clear when we're dealing with a delegation of a trustee's powers that it's in the capacity as trustee. Like, it has to be spelled out, refer to the exact power and make it really clear. I would just check if there's anyone prohibited from holding a particular office, either in the Constitution or under regulatory rules around the type of business. Then the attorney does have the qualification. If your deed requires any notice requirements to the trustee resolutions approving the appointment, all of that, that you go through that process. Check if there's any existing powers of attorney for the entity in place already and look to revoke them. And in this case, I don't think this is an autopilot solution. You really do need to work with the clients to play out the scenarios that the document is going to be needed for and the scope of the power of appointment. Like, that is where you're really going to add value rather than just rolling out a generic template. So that's really the end of the presentation, but I've got a little bonus section. I've specifically focused this on law firm owners, but if you are a accountant or financial planner running your own business, think about this from your perspective as well. But I put this together for the lawyers in the TT Precedents Club especially, and I wanted to mention it here. So have a look. If you are a principal of your practice or an owner of your law firm, go and have a look at what your law society says is going to happen if you lose capacity or die, and think about what's going to happen to the firm if you're not there, especially if you're a sole practitioner. So in Queensland, I've just picked on Queensland and Victoria. Those were the two easiest to get access to. I'm a registered lawyer in Queensland, so I got all of Lexon's information, and Victoria had made theirs public, but I don't know if the others have. But so go and check this out. Okay, so in Queensland, if you are a sole director of an incorporated legal practice and you die or lose capacity, then the Law Society and Lexon can come and sort things out, but only if you have a power of attorney in place for your firm, okay? So you need to have, if you're a sole practitioner on your own, a specific enduring power of attorney with a financial power. If you're like trading as a person, what's the word? Yeah, sole practitioner. If you have a company, either as trustee of a trust or just trustee as an incorporated legal practice, your firm needs a general power of attorney. Your personal financial power of attorney is not enough to authorize Lexon. And they've set up here, Lexon is unable to enter your law firm or assess your files without it, right? They've got a whole lot of like trespassing. No, there's no director to authorize them. There's client confidentiality, privilege, all of that. So they cannot sort it out for you or keep your law firm going without it. And if you don't have a lawyer with a principal practicing certificate stepping in as the director within 7 days, your firm has to stop trading. In Victoria, the same situation applies as well. So, where's the section here? So the board of, I don't know what the board stands for, the LIV board, I presume, like needs to appoint a manager to come in and sort it out, and they can't do it. This is a lengthy, disruptive, and very costly process without a power of attorney in place, costing you up to $40,000. So you need to have a power of attorney. So we have actually put together a power of attorney precedent. It's for general clients, it's for company like for you to use with clients with companies and trusts and maybe a self-managed super fund if you find the case for it that you can use with your clients, but you can also use it for your own business. And there's specific user notes and clauses where you are running a law firm. So the things, if you are looking at it from your own perspective as a law firm owner, think about, who's going to be your attorney. Is it another lawyer with a principal practicing certificate, or is it like a non-lawyer? Like I think some of you might think about appointing your spouse, and then they need to work with the law society, and your spouse as the attorney would need to hire a lawyer with a principal practicing certificate right away. Some of the jurisdictions require that the attorney is a lawyer with a principal practicing certificate. So I know that some of the lawyers in the TT Precedents Club have actually done a buddy system where they're appointing each other, like they're just finding another sole practitioner member in the club and appointing each other, doing a deal. Yeah, that's right, Josephine. Yes, so I think New South Wales is one of the cases where you have to do that. So, find someone a friend who runs a law firm themselves who needs it, and you know, appoint each other. In Queensland, we don't have to appoint a lawyer specifically, but if you don't have anything in place, it's going to be a huge mess. So just to reiterate, if you are trading as a sole individual practitioner, then you need to deal with this in your personal enduring power of attorney. Maybe consider if you need to appoint, like especially if you're in New South Wales, like Josephine said, if you have to appoint someone else who's not who wouldn't normally be your enduring power of attorney, then I think you could make a separate enduring power of attorney with limited powers relating only to the business, and just confirming that it doesn't revoke your main existing enduring power of attorney. And then if you're trading through a company or trust with the corporate trustee, then do the general power of attorney. If you're trading through a trust with an individual trustee, then you need to fix that up quick, smart, and put a corporate trustee in place, and then do your general power of attorney. So we've drafted very comprehensive clauses and powers, trying to think of everything that you might need to cover in our precedent that is available for purchase. But these are the types of things we thought about. Do you have a trust account? Does the attorney have the necessary trust authorizations? If you're not appointing someone who's a lawyer or who has a principal practicing certificate, allowing them to hire a suitably qualified principal practitioner, the timing, remuneration around this, particularly like where you're doing that swap of attorney, like with another law firm owner coming in to triage your practice. Like, can they charge fees on your client files and get paid for that, or are they going to be paid a salary? Like, how are we going to deal with all of that in terms of remunerating them? Can they engage their law firm to continue the carriage of the matter, or pay for themselves? It's quite it's quite, when you think about it, you don't want to be lumped into being someone's attorney or agree to that if you haven't worked through this detail. Danielle, good question. Is someone appointed to act under a company power of attorney registered as a director of the company? No, they're not registered with ASIC as far as I'm aware. The authorization would be their power of attorney deed. So you would have a different execution clause saying they're signing on behalf under the power of attorney deed. So the due diligence, say it's a contract with a bank or a third party, the due diligence that the third party would want to see is the general power of attorney, and then the directors remain the directors. So the directors can sign on behalf of the company, or the attorney can sign on behalf of the company, if that makes sense. And then in the company situation, say our director lost capacity, that's where the shareholder would pass a resolution to appoint a new director, and that new director gets notified with ASIC as the director, and then the new director could decide to revoke the general power of attorney if they decided it didn't align with the business anymore. I hope that makes sense. So back to our scope of appointment for the general power of attorney for like a law firm, things that we want to be expressly saying is they can pay staff the salary and wages, obviously. You don't want to walk out because no one's getting paid. They might need to hire and fire staff, probably more hiring, but like hire them and hire themselves to come in. They're going to have to consult with your law society and insurer and, work out a plan, review every matter, review where everything's at, work out what's going to trial, urgent dates, the whole thing. They may have to give legal advice to clients that the entity is then liable for review files. They might even can they wind up the law firm? And having like the express authorization to do or not do that is really important, especially for incapacity. If it's a shorter term incapacity or something, and you come back, you regain your health and you found out someone's wound up your law firm, so really being specific about all of this and dealing with it in there. So I am happy to take more questions if we've got them. I do appreciate I've gone a little bit over. If you are looking at sorting this out, either for clients where you think, oh yeah, this is a good opportunity to recommend this for them, or for yourself, we have got a entity power of attorney precedent pack that we've put together. So it's different. We've got 2 lots of general power of attorney deeds, one for trusts, one for companies. We also give you a deed of variation for trusts if you need to update your deed to include the express power to delegate. There's a template there ready to go, so you can update that. You don't have to go and draft a clause or find one out for yourself. There's express wording in there for law firms. There's express wording in there if it does happen to be a self-managed super fund, because they've all got, when you dive into the detail, there's different things we want to see in there. Depending on the nature of the entity and the activities. There's a cover letter with advice to clients. There's very detailed user notes. So that's $650, including GST. If you're a law firm owner, it's a no-brainer, right? Because you buy it for yourself, get your own succession plan sorted, and then you can also use the precedent for your clients as well. So I will throw the link to that in the chat if you're interested. I'm also just checking if there's any more questions. Otherwise, we might wrap it up. And I just want to say thank you, everybody, for joining me today. Thank you for the questions, especially, and contributions, Danielle, Josephine, and Jennifer. Oh, and yes, thank you for that comment as well, Danielle. I really appreciate that. So yeah, we might wrap it up. Thanks. It's been great to come back. I have been on maternity leave for most of this, and Carrie's been doing an amazing job carrying on. Pardon the pun. But yeah, it's lovely to come back. Thanks for having me. Take care.